Today, we're going to explore the very foundation of our legal system and how technology is forcing us to rethink its most basic principles. This explainer is based on the works of Professor Vihar Kiskinov. Here's our roadmap. We'll start with the fundamental building block of all law, then trace its surprisingly quiet history. From there, we'll see how technology completely changed the game, creating some serious challenges. And finally, we'll look at a new way to think about the law for our automated future. So, to really understand any legal system, you have to start with its smallest, most essential part, the legal statement. It's the atom, the single brick that everything else is built from a simple sales contract to the constitution of an entire country. Now, at the heart of this is a simple human act, a statement of will. This is just you expressing a decision. It could be anything, really. I will buy this coffee, or I agree to the terms of service. The key is that it's a complete, formulated decision that you've expressed. But what makes a simple statement of will into a legal statement? Well, the magic ingredient is the law itself. A legal statement is any express decision that the legal system recognizes and, crucially, attaches specific consequences to. That's what creates rights and obligations. So, for a statement to get this legal recognition, it generally needs 4 qualities. First, it has to come from a genuine will. Second, the decision has to be final, not just a maybe. Third, it has to be expressed somehow, spoken, written, even a click of a button. And finally, it has to be valid, meaning it follows all the rules the law requires for that specific act. Now, here's what's so fascinating. Even though this concept is absolutely fundamental, for most of history, no one really developed a general theory about it. Its evolution has been surprisingly quiet. If you look back, Roman lawyers dealt with specifics, like mistakes or threats in a contract, but they never stepped back to define the legal statement as a whole. The idea slowly took shape over centuries, but it was always tucked away inside specific areas, like contract law. And, believe it or not, even today, you'd be hard-pressed to find a major legal theory course with a whole chapter dedicated to it. For a long time, not having a unified theory wasn't a huge problem, but then the digital age arrived, and suddenly, virtual environments and automation started to challenge everything we thought we knew. You see, for centuries, the law was built on a simple, unspoken assumption that legal statements come from rational human beings. It was just considered a self-evident truth. But technology forces us to ask a really radical question. What happens when the statement doesn't come directly from a person anymore? Just think about how e-government or e-commerce works. An IT system gets your online application. It automatically applies a set of rules, generates a legally binding document, like a permit or a certificate, electronically signs it, sends it, and logs the whole thing. This happens millions of times a day with no human looking at each individual case. This new reality is putting our legal system under a huge amount of strain. Because we never bothered to create that unified theory of a legal statement, we're now trying to govern this brand new world with a messy collection of old, mismatched tools. The result? A legal mess. Instead of creating one clear set of rules for the digital world, lawmakers are just creating new specific laws for every new piece of tech that comes along. This creates a confusing, contradictory, and often dysfunctional system for everyone. And this slide shows you the problem perfectly. Let's ask a simple question. When is an electronic message legally received? You'd expect one answer, right? Well, the E-Government Act says it's received the second it hits the government server, but the tax code says it's only received when the person on the other end sends an acknowledgement. The E-Commerce Act says it's when you just have the chance to access it. One simple action, 4 different and conflicting legal answers. That's patchwork legislation in a nutshell. So, what's the solution? Professor Kiskinov argues we have to go back to the drawing board. We need to completely rethink the concept of the legal statement to build a foundation that actually works for the digital age. And the key insight is beautifully simple. We have to make a clear distinction between the source of the will and the source of the statement. The will, the actual intent, that always comes from a person. But the thing that actually forms and delivers the statement, that can be a person or it can be an information system. Once you make that distinction, a whole new map of our legal world opens up. We're not just dealing with human-to-human interactions anymore. Now, there are 4 types. A person can make a statement to another person, like in an email. A person can make a legal statement to a machine, like when you fill out an online application. A machine can make a statement to you, like that automated approval notice. And this is the big one. Two machines can now make legally binding statements to each other. By adopting this new way of thinking, we can finally start to build a legal system that makes sense for our automated future, one that's coherent, consistent, and up to the task. Remember how we started? We said legal statements are the law's building blocks. For centuries, we were building with them without a clear blueprint. To build a legal structure that can actually stand up to the pressures of technology, we finally need that blueprint, a general theory that understands all the new ways these blocks can be put together. And this leaves us with a deep and challenging question for the future. When an automated system makes a legal choice and something goes wrong, who's really responsible? The person who wrote the code? The organization that used it? Or could it, one day, be the machine itself? These are the questions we now have to face.